All right, buckle up. We are diving into a chaotic day in court, where the line between legal defense and total meltdown gets dangerously thin. We got defendants claiming their lawyers are undercover agents, judges losing their patience, and a heartbreaking plea that reminds us exactly how high the stakes are when family is on the line. Let's break down why this first defendant is convinced the entire room is conspiring against him.
Because once again, because you bear no responsibility in any of this.
You don't even know me as a person. You're going by a piece of paper.
Right.
That's I could be custody of my daughter.
That's when you're pointing. People need to realize that when you're pointing at a
she's working against me, you're working against me, the district attorney is working against me, and you're not listening to me.
Yeah.
And everybody hears me. Hey, look, now they're gonna talk. Yeah, you don't need them today.
I do my best to remember everybody so that you will know that you're not just a number to me. And it's easier for me to remember faces and names as opposed to SID numbers. I had one client, though. His SID numbers were 3 digits, so that was easy to remember. And you know what that means if your SID number only has 3 numbers.
Okay.
Oh, yeah. When I would go see him at the jail, the people at the jail, no, Stephanie. I'm like, no, those are his numbers. And then they're like, oh, my gosh. So he had a case from, I think, 1960. So that is why he had the 3-digit number. Oh, yeah? Oh, wow.
Did you catch that? The judge is trying to explain Law 101 here. In a world of TV dramas, lawyers always get the miracle dismissal. But in the real world, if the state has the evidence, your lawyer can't just wave a magic wand. This is a classic breakdown in the attorney-client relationship. Question for you guys. If you were the judge, would you grant him a new lawyer just because he's unhappy, or is he just stalling the inevitable? Let me know in the comments.
All right. So, Mr. Bernal, do you want a jury trial or a bench trial? What do you want?
Judge, he wants a new attorney.
Oh, why?
I don't think she's serving my best interest. I'd like to hire her.
All right. So here's the thing. Let me explain something to you.
Rightly said.
Sometimes, and it's okay if you want to hire an attorney, that's fine. Sometimes people think an attorney is not working in their best interest because that attorney is not giving them what they want. Sometimes people want a dismissal and the attorney says, well, I talked to the state. State says they're not dismissing it. They can't force the state to dismiss a case. If you want a dismissal and the state says, no, we have enough evidence, we're not dismissing it, then your choice is, hey, either you accept that they're not going to dismiss it, enter into a plea bargain agreement, or either you go to a jury trial or a bench trial. But your attorney can't force the state to give you what you want. That's not really how it works. The way negotiations work is they'll go to the state. Maybe your attorney will tell the state, hey, I see some bad issues with your case. This is what you're going to have a problem proving. And then the state will be like, oh, I didn't view that. These prosecutors will do that. I don't know what other prosecutors are doing, but they'll say like, oh, I didn't consider that. Let me look into that. And then they'll probably look into it. And if everybody agrees on what they're seeing and what the issues is, they may say, you know what, we are going to dismiss it. But you're charged with the burglary of a building. So burglary of the building cases, they're very simple. Drug cases are very simple in terms of what needs to be proved. So if your attorney is not giving you what you want, which may be a dismissal, that doesn't mean that they're not working in your best interest. It just means that the state said they're not going to dismiss it. State, on Rafael Bernal, are you all going to dismiss this case?
We will not be judged.
So is there anything that the defense can do to make you dismiss this? I guess other than that you're on video at the picnic with the pastor or something. You know, I said there is nothing that she can present to them that is going to make them want to dismiss your case. They're saying they're not going to dismiss it. Is that correct?
That is true, Judge.
Is there any information that the state can bring you
That defense could bring us?
Yeah, I'm sorry, that the defense could bring you to have you dismiss this case?
There is not, Judge.
So they're not going to dismiss it.
Hey, everything that you said prior to this about how you're not doing her job,
No,
that's extreme.
I'm not saying she's not doing her job. What I'm telling you is it appears that you, and I'm using it as a hypothetical, you want a dismissal. The state is saying they're not going to dismiss your case.
But she hasn't also given me the proof of why I don't have a case for dismissal. She's never given me. I need to look at the proof to see what proof they have to convict me.
All right, so let's do this. Could you go over the paperwork with him again?
Yes.
All right, and State, could you make sure that she has your file so that she can show him police reports and everything?
Certainly, Judge.
On the record, respectfully, Judge, I have shown him all of the documents that we have in the state's file. He's looked at the state's
No, here's the thing.
Yeah.
Sometimes,
We'll do it again.
yeah, sometimes people go to the jail and maybe they forget certain things. I don't know, but she's going to show it to you today. And she's going to explain to you, according to the penal code, what burglary of a building is. All right. Part of it is going inside a building without consent. So that's part of it, right? No. Here's the thing. That's part of it. So she's going to go over that with you and show you what's in the police report. Okay. And then we'll come back. But what I want you to know is when you're sitting over there, the state is saying they are not dismissing the case and she can't force them to dismiss it.
I understand.
Okay. Okay. All right. All right. Thank you. Just have a seat.
May I make sure, just on the record, he has made very clear that he does not want me representing him, that he wanted to retain an attorney. Do you still want me to
Oh, yes.
Okay.
I mean, do you have an attorney here today?
No.
All right. So yes, you're his attorney.
Okay.
All right. Thank you.
So I just don't want to complain. Yeah, she's ordered.
No, she is going to show you
Right.
all of the documents that the state has against you.
Okay.
And then once she's shown you that and you've read it, just come back before me. Okay. All right. Thank you.
Thank you, Judge.
Thank you, counsel. Mhm. All right. Jesus Santoyo, are y'all ready? Oh, Mr. Bernal.
No.
Stay fine.
Pay attention to what the judge just said about washing her brain. In legal terms, she's referring to inadmissible evidence. Since she's the one who would decide a bench trial, she cannot legally consider plea negotiations that fell through when determining guilt. It's a mental reset button. But look at Mr. Bernal. He's not interested in legal procedure. He's looking for an exit door that doesn't exist.
So you want a jury trial, is that correct?
Yeah, I was out for 8 months.
No. Here's my question. Legally, I'm not supposed to hear what plea negotiations y'all have made because legally those are supposed to be confidential.
Right.
So I'm going to wash my brain of what you just said. So my only question for you is, are you reaching an agreement with the state or do you want a jury trial? That's either yes, I want a jury trial, or no, I don't want a jury trial. All right, so here's the thing. We've been here on this train before. So the train stops here. Do you want to, if you want a jury trial, I will give you a jury trial. So do you want
I'm a lawyer.
well, do you have money for an attorney?
No.
All right, then that's where we are. This is your attorney.
No.
All right, so you're going to represent yourself?
No, you can hire me another attorney.
No.
Judge, respectfully, I'm sorry. Can I speak to my client for a second?
Yes.
Mr. Brown, can you step over, please? Step over, please.
Working here. No. She just said, they don't send you to prison just because you don't have money. I don't have money, I need another attorney.
All right, let me stop.
Another attorney.
Now, just 1 second. Let me ask you this.
Yes, Judge.
Are you appointed or retained?
Appointed.
All right, you're appointed. So what that means is that the government, the state of Texas, the taxpayers, because you can't afford an attorney, had this attorney appointed to represent you.
Right.
So this is your attorney. If you want another, if
Mr.
you want another attorney,
Yes.
then you need to hire one.
How?
I have no idea. All right.
You don't have no idea.
May I present the case?
I'm telling
May
you
I go
now.
forward and try to represent him? He has,
No, you
think
will find me
he's upset.
another lawyer.
I think he's upset, and it's possible that I mentioned before, he's very knowledgeable. He knows a lot of the law. It's old law. I've tried to update him on some of the laws, on some of the charges that he has had in the past, and the charge we're talking about today, which is burglary of the building. I
It's a
explained the
repeat.
difference.
The time I was here before.
We're not gonna-
No, I need to explain.
So what I
It
would
was
like
the
to do right
same
now,
thing, burglary of a building, and it was dismissed. And now it's a repeater.
Let me ask you something, Mr. Bernal.
Yes.
You're Raphael Bernal?
Yeah.
What do you want to say?
I just said it.
No, what do you want to say? We're here to listen because you keep interrupting your counsel. So nobody's going to say anything. I'm going to let you speak. What is it that you want me to know?
What did you not hear?
I didn't hear any of it.
Why not? Everybody heard.
No, they did not.
You didn't hear it.
No, they said they did not. So what is it you want to hear?
Mr. Judge, can we get a second, please? I'm sorry.
No, that's okay. Sometimes, counsel, I understand where you are, but sometimes when people don't get their way, they behave childlike, which is fine. So this is what's going
I'm
to
64 years old. I'm older than you.
counsel. You assume that. Counsel,
What did I assume that?
counsel, this is what's going to end up happening. You're going to go to jury trial. You will be his attorney. If he doesn't want to take your advice or listen to you, then he doesn't take your advice or listen to you. But people need to realize that when you're appointed, people need to realize that when you're appointed an
She's
attorney,
working against me. You're working against me. The district attorney is working against me. And you're not listening to me.
Yeah.
And everybody hears you. Hey, look, now they're gonna assault me.
We're not assaulting you, we're just.
Yeah, you don't need to do that.
thank you.
You're welcome. So the bottom case number is one that only shows up as being sentenced to, the top two need to be concurrent with it.
Thank you.
I'm sorry about that.
Hey, here's the
And just like that, Bernal is out, and the energy in the room shifts from frustrated to somber. We're moving into the case of Miss Rice. This is where the system meets human struggle. You're about to see a defense attorney fight for a mother's freedom, while the prosecution points to a mountain of failed drug tests. This is a downhill spiral the court keeps mentioning. Let's see if the judge shows mercy.
You know what I always say?
It's one of those days.
No, it's fine, but
Well, even for me too. My short
Monica, just one of them days. But here's my whole thing. Everybody needs to stop apologizing for other people's action. That's a grown man. There's no need for you to apologize for him.
It offends us to see
Sorry,
It
Judge.
does, yeah.
So bad.
Don't feel bad. That's not you. Cornelius, you know what my grandmother would always say? I don't know why you're feeling bad. That's not you.
I'm like, can you please stop it? Oh my God.
Oh, wow. I don't think this is the first time we've ever heard the word BS.
I didn't expect that. I'm sorry.
Yeah.
I did not expect.
Cornelius,
I think it's right.
first that reminded me of, do you remember that movie Injustice for All?
Yes. You're out of order.
I'm going to come back on September 9th for jury trial.
Okay.
Thank you for your patience.
Thank you for your judge. I know just a little bit.
No, do not feel bad for other people's actions. And there's no need to apologize.
Okay, Judge, I got
Yeah.
that one, and I have one more, but I'll step out.
Offense and pass interference on the defense.
Yes. Family line speaks to you there, Ron.
Yes.
Now you can go.
Miss Rice, you should be grateful that it's being dismissed. Are there new charges from this alleged incident that occurred the other day?
So there are new charges pending in district court that have already been filed. I think it's a trespass, but it might be just an assault.
I think it's an assault and battery.
And then Mr. Close advised us of an incident yesterday that may also have new charges. Those will obviously be dealt with in district court separately. And I, again, don't want to discuss these charges, but I think at this point, it's best to move forward and not make Ms. Rice's ex and son testify if it's not necessary.
All right, so, with regard to sentencing today on the contempt, are we ready to receive that? Right, do people have any position on sentencing before the court proceeds?
Just like I said, I do think the maximum on the contempt of court would accurately reflect the delays in this case. Time is often in favor of the accused, and it certainly has worked in Ms. Rice's favor in this case. But that being said, I think the maximum on the contempt is more than fair, given her number of positive tests, including today being positive, and given I could go back and see how many times this was delayed based on her non-appearance, but I don't have that figure right in front of me on both cases, and as well, that's not even counting the district court where she had failed to appear and was arrested in district court before it was found over. So thank you.
Mr. Moore, anything you'd like to say on behalf of Ms. Rice?
Go ahead, Judge. Could I have represented Ms. Rice almost since the time I started public defender's office? So I'm very well acquainted with Ms. Rice and all of her legal troubles. That being said, Judge, none of this is an excuse for her behavior, but 3-4 years ago, it's fair. Well, first of all, and I think this court's also well acquainted with Ms. Rice as well. Whatever happened prior to that is certainly played a great deal on her emotion, how she handles things at an emotional level. And I think as we all know, when we let emotions take control of our decision-making process, we usually make bad decisions. And Ms. Rice is engaged in counseling and therapy and will probably need it for a very long time to help her get past that area where she lets her emotions take control of her decision-making process. That being said, there are times where she is she has some good attributes. One is she's a good mother. And I know that this court could argue and not actually argue, but state that how can you be a good mother if you're using drugs that you should be using? And there's no debate with that. But by all accounts, through her CPS case, which I handled, and through today, her primary focus for the last 3 years has been her children. She has two. She is the primary caregiver. The fact that CPS has closed the file on her shows that she's committed to continuing to be a good mother.
That was quite a while ago.
About 10 months, maybe. I think it was December, October. But she has continued to make strides to getting housing, getting the services she needs. Guardian, the last time we were in on that case, I had no issues with her as her parenting skills. Ms. Rice faces many challenges, Judge. She was in district court yesterday, and I was present for that hearing, and the judge, spoke to her. And one of the things that's apparent is Ms. Rice has so much burdening her. Children, these pending cases, which I think if we can get them, if these are finally resolved today, will be a great help in getting her past that. Remove those stressors. That I think will help her life settle down somewhat. She can spend more time focusing on her children. I think she tends to put too much emphasis on things and uses that as a way to justify some of her behavior, such as not appearing in court, not attending certain things. And I certainly understand the state's point of view on this and their situation. But I think this is a good resolution. I think that the longer she's in jail, the more risk her children are. And so with all of that being said, Judge, and knowing Ms. Rice and knowing that she actually has She has to be in district court on this assault charge this morning yet. So I told her to come here first, and she did. I'd ask the court to use its wisdom and fashion the most appropriate and lenient sentence as many jail time as it possibly can. That would be our request on Ms. Rice's behalf.
Ms. Rice, is there anything you'd like to say on your own behalf? Okay, I need you to go stand at the podium for me.
Three years ago, when Eleanor was born, at Toledo Children's Hospital, her meconium came back. Method with methamphetamine in it. And I have not touched it. I never touched it. And so they did a very extensive and intrusive test through ProMedica. Eleanor had zero withdrawal. Zero. They monitored her for 6 hours. She had zero withdrawals. Not one withdrawal did she have. None. Because I wasn't using that drug. But the drugs that I take through my doctor, Noble. And Dr. Noble told me and my case manager that's in her office, they caused a false positive. When Memphis was born, his meconium came back with the same exact test results, but they didn't even go through what they went through. They didn't call CPS. CPS never got called because they knew that it was verbatim the same exact as Eleanor's. My kids will lose everything that I have worked really hard to get where we're at. We will lose it all. When I went to jail this last time, I lost my daycare for my kids, which is why I had to bring them to court. I reapplied. I started all over. I started all over all of my stuff again. This thing downstairs that happened. I need to be able to fight that because it's a lie. I didn't put my hands on her. She put her hands on me and my kid.
All right, so ma'am, I don't want you to talk about any pending cases because everything you say can be used against you because this is a court record. All right, so don't talk about events that occurred on your case. Say that to your parents.
I know that my kids will be in foster care if I go to jail. I don't have anybody to watch them. Their dad has not seen them in over 2 months. I have climbed out of my trenches. I've climbed out of them by myself. I've worked by myself with them in tow, and we need each other. And they need me, and I'm not using.
Oh. Mr. Post, you administered a test today to her, is that correct?
Yes, ma'am.
And did she test positive for anything?
Test positive for THC, amphetamines, and also methamphetamines.
Now, we know she's on Adderall, but her levels were extremely high, so that would be more than it would cause a positive.
The two or previous tests was a swab that was actually sent to the lab. I did talk to the lab. They said the only thing that would make methamphetamine turn positive is methamphetamine. Go through a false positive because of Adderall.
True. All right. So, Ms. Rice, back now, I realize that you completed a CPF case. You had your children placed in your care, and the case was closed in October. But what I will tell you, what I've seen is you go downhill since then. I'm talking now, not you. So, on April 17th of 2023, there was a motion affidavit bench warrant because you failed to call in pretrial services coordinator Barry Post on a daily basis. There were no call-ins from 4/10/23 to today. It's dated on April 17th. Let's see. I have a drug screen collected 6/23 that shows a positive test for methamphetamine. So then, let's see, we'll go to the next one. On May 16th, May 16th of 2023, you failed to appear for warrant on May 16th of 2023. There's a bench warrant. And let's see, this one was filed April 18th. Let's see. Prepare bench warrant arraignment. I have a failure to appear for bench warrant arraignment on May 16th. And then May 16th. I have pretrial release order to comply with CMH recommendations and medications. We've had multiple tests that were sent in on swab showing your levels are dangerously high. So, no, Ms. Rice, I'm talking. So, Ms. Rice, I have great concerns about your mental health, your physical health, and your just defiance from day one of the court's orders. And
93 days. That is the moment the heir leaves the room. Despite the charges being dismissed, the judge is using her power to punish the contempt of court, the failure to follow previous orders. This is a massive law and order moment. You can win your case and still lose your freedom if you disrespect the court's process. The reaction you're seeing now, that's the raw, unfiltered terror of someone realizing they won't be going home to their kids tonight.
Also a downhill spiral that I'm seeing in your behavior. Court's orders are in place, and while I have great sympathy for your trials and tribulations, I also feel that you have taken advantage of that to some extent, trying to manipulate the court. But based on just overwhelming issues I've had for you with you and your failure to comply with court orders, I think you got off very lucky today because the charges are being dismissed. But I am going to send you to court or to jail for 93 days. Well, get credit for any time you've already served. Thank you. No.
I'm begging you, my kids are gonna be in foster care. I'm begging you. I'm begging you. Don't touch me. Don't touch me. Please make mine out.
No, you're gonna get credit. You're gonna get credit. No.
Thank you.
Mr. Matthews.
Thank you, Your Honor. Excuse me. We are asking for community control for Ms. Rude. She's been in jail for 86 days. As a result of this incident, there is now involvement with the juvenile court in relation to custody of her daughter. Her daughter is currently staying with Ms. Rude's parents. Ms. Rude is hoping to be released so that she may immediately address that issue. She does understand in speaking with her that the most pressing issue that she has, if she's going to be successful on community control, will be dealing with her mental health issues. And she has expressed that she is prepared to deal with those issues and follow what recommendations are made. Thank you.
Okay, Ms. Rude, what do you want to tell me?
I want to say I apologize for coming into your courtroom. The relationship that I was in was just a very toxic relationship and a very abusive relationship. I take full accountability for what I've done, and I've learned a very valuable lesson while within your jail. I do not plan on coming back within your jail unless it is like for me to see my probation officer. That's what's granted today. And I'm going to try to get my mental health in order.
What is the extent of your mental health issues?
I don't understand.
Well, what's your mental health diagnosis?
I have CPTSD.
You have what?
CPTSD.
What's the C stand for?
Complex.
Who diagnosed you with that?
Signature Health and Crossroads.
What is complex as opposed to regular PTSD?
It's recurrent flashbacks.
What other issues do you? What other diagnoses do you have?
I have ADHD.
Anything else?
Intermediate explosive disorder, and I think that she said battered woman syndrome.
What treatment have you been undergoing prior to this arrest for those issues?
I go to Signature Health, and I was in EMDR therapy.
What happens at Signature Health?
I talked to my therapist.
Who's the therapist?
Leno Banbrook
Which facility is that at?
in Willoughby,
How often did you see this therapist?
once a week.
And were you on medication?
I was supposed to start taking one. I'm only on ADHD medication right now.
Why not the other medication? Why not medication for other conditions?
In the past, I've had adverse reactions to meds, and I was afraid to take one. I've been medicated since I was a kid.
How long have you been going to Signature Health?
Since I was a kid. Since I think I was,
Constantly, at a regular basis?
yes.
So, like, by regular, what do you mean? How often had you been going?
I go once a week to see my therapist.
How long have you been going once a week?
For the last 9 months.
Okay, what about before that?
A little after I had my daughter. My daughter was 3. And then stopped going when my daughter turned 4. And went again when my daughter turned 5.
You said you've been going regular since you were a kid.
Yes.
Okay, so tell me about between when your daughter was born and when you were a kid. How often were you going?
When I was a kid, I was going to Crossroads, and then they transferred me over to Signature Health. My parents would take me. My old therapist was Dr. Mickey.
How come any of this hasn't resolved your problems or helped your problems?
I'm still kind of trying to understand PTSD. So,
Well, you've indicated that you don't take the medication because you didn't like the medication because of the way it made you feel, right?
I've been cleared from having to take medication.
Cleared by who?
My psychiatrist, Jenna Crockett.
So why are you seeing a psychiatrist if you don't get prescribed medication?
I do get prescribed medication. I take Vyvanse. I haven't been prescribed medication for PTSD.
Why are you still trying to contact Joyner?
He lives at my house, so he has things at my house.
So that's why you were trying to get in touch with him or his family members as recently as Friday night?
We're here in court, so I was trying to see if he was going to be here in court. I talked to him also on the 21st in jail.
Okay.
He said that he spoke to the prosecutor, and he said he asked the prosecutor to drop all the charges. He told me to plead guilty to domestic violence, and that would be the only way that I get out of jail.
He told you that?
We were on the phone in jail on the 21st of last month. The 24th is when I had court, which was the following.
So he told you to plead guilty to domestic violence, and that's why you pleaded guilty to it?
He said that the only way that everything will be resolved is if I was to plead guilty to domestic violence. He said that he wanted to press charges originally, but he told the prosecutor that he no longer wanted to press charges. He explained to me that the state picked it up and that he was sorry that I was pending all of these cases or these charges. We agreed to go our separate ways. We still have been slightly in communication, but we haven't been seeing each
I
other.
assume there's a no contact order.
Now we're looking at Miss Rude, and this is a masterclass in how not to handle a sentencing hearing. She's quoting other inmates and telling the judge that her therapist told her to resist specific treatments. Pro tip: never tell a judge you're taking legal or medical advice from a cellmate. The judge is clearly skeptical of the complex PTSD claim, not because she doesn't believe in mental health, but because the defendant's story keeps shifting. Does this feel like accountability to you, or just a really desperate defense?
Right?
Unfortunately, yes. I don't plan on talking to them from here on out because now there's a Child Protective Services case open. And
So what happened back in February with this incident?
I don't understand.
What happened in February, this is December 31. What happened December 31 of last year?
We both were drinking. It was New Year's Eve, and things got really out of hand.
How?
We got into a serious argument. He was threatening to expose my medication bottles. I'm a licensed manicurist.
Expose your medication bottles? What do you mean?
I have, we both have herpes, and he thought that I was cheating.
Okay.
And he was threatening to expose my medicine bottles on Facebook.
Okay. You get in this argument, and what happens?
He said that he's been waiting to set me up for quite some time, because he was arrested for burglary.
All right, so then when the police arrived and you knew they were there, why were you blocking the door, keeping them from getting in? If he was threatening you?
I wasn't blocking the door here.
You were blocking the door. I read that portion of the police report where you were blocking the door. They kept telling you move. You refused to move. And then when you finally moved is when they got in. So why were you blocking the door?
I couldn't move. He had me by my hair. We were in my living room.
Okay. All right. Then they went in there. Why were you completely out of control? And they had to carry you out. They had to call two other departments to carry you out of the door to put you in the car. And you were kicking and screaming the entire way. Why were you doing that?
I have some trauma in my background from sexual assault. And
you've got a lot of problems that you haven't dealt with. Despite what you're telling me, okay, you haven't dealt with it. You may or may not go to Signature Health, okay? But whatever you're doing there, and whatever you have done there, hasn't worked one bit. Now, you were interviewed to go to NeoCap, and you were screaming at the lady that was trying to interview you such that she couldn't interview you. Why were you doing that?
Because from what I'm hearing, NeoCap has a therapy called cognitive behavioral therapy. And I'm a victim of sexual assault. The reason why I didn't calm down when the police came because there was...
No, I'm talking about why you were screaming at this lady from NeoCap.
I don't want to go to NeoCap.
Why not?
They have cognitive behavioral therapy.
Okay, what's that?
It's a therapy that's not good for people that have PTSD.
How do you know that?
I talked to my therapist, and here, her name's Bree from Signature Health.
Okay, so Bree from Signature Health told you to resist going to NeoCap.
No, she didn't say resist. She said she didn't think that would be good for me because...
Is Bree here somewhere that I can't see?
No,
Do you know who this Bree is, Megan? This is why I never sent people to Signature Health, okay? So did you tell this person from NeoCap that you didn't want to go there because they have cognitive behavioral therapy and Bree told you it's no good for PTSD?
No, I told her that I have a daughter and it would create a separation, more time away from my daughter.
So which was it? If they didn't have cognitive behavioral therapy, would you have gone there?
No.
Okay, because of your daughter.
Yeah.
Okay, so you didn't want to go there because of the cognitive behavioral therapy, because of your daughter, and why else?
Those are the only two reasons.
Okay.
I don't think that, also they don't have, from what I'm hearing, the other inmates were saying, they don't have any.
So let me stop you there, because the last thing that you should be listening to is the other inmates, because not a one of them know what the hell they're talking about. So you'll listen to them, but you won't listen to anybody else. You won't listen to the lady from NeoCap tell you what that has to offer and why that may be good for you, because you're listening to the other inmates because they told you something about NeoCap.
The lady said that they don't have any church there either.
Okay. What lady was that?
I spoke to the NeoCap lady.
The one that you were screaming at that couldn't interview you because you were screaming at her uncontrollably? That one? Were you screaming at her the whole time or just part of the time?
I cried almost the whole time.
It strikes me from reading everything that you have no insight as to what your condition is. And you certainly then have no insight as to what you can do to treat your condition. That's clear to me.
I had an appointment with my psychiatrist to get on medication. I'm not medicated in jail because you guys don't even allow stimulants.
You weren't taking medication anyway because you don't want to take medication.
I was going to start taking a medication. I had an appointment set up for the 14th, but I got placed back in jail.
Why did you get placed back in jail?
Because there was a protection order, and I reached out to my ex-boyfriend to come pick up his things from my house.
So why didn't you listen to the protection order?
I should have called the police, and I hold myself accountable for that.
Why didn't you?
Because the police, when they kicked my door, and they had the guns pointed at me, and it scared me.
Well, why did they have their guns pointed at you?
Because my ex-boyfriend lied and said that I had a knife, and I was in front of the door.
Well, you were in front of the door, blocking them from getting in.
No, I was not. We were in my living room.
Were. Now, you can argue with me all day, but I'm going to get the last word, okay? Because if I have to believe the police account of it or yours based on their observations of you, I'm going to believe them 100 out of 100 times. And then you're causing problems when you're in the jail. Reports of you causing problems with other inmates when you're in the jail. You were causing a problem on a certain range, and they told you to calm down. They tried to talk to you. You wouldn't listen. and then there was a lockdown. So no insight into your condition, the severity of your condition. You certainly don't know what to do to make it better. That's where you're at.
I had an appointment scheduled for the 14th of last month. I didn't make it to the appointment
How long you been in jail?
since the 12th of February
And you scheduled an appointment for April 14th?
when I was out on bond.
Okay.
I saw the discovery packet. I do realize that it does not look okay. I've been out of work since last October. I pulled myself out of work. I'm on a medical leave from work. I know that I have post-traumatic stress disorder. Like, I know. My condition is not always bad. It's gotten really bad. It's not always bad. That's why I haven't always been medicated. I've been cleared by my psychiatrist and I have to be medicated. Post-traumatic stress disorder with CPTSD is different than the average PTSD. It's recurring. So it can leave, symptoms can leave.
Well,
and then they-
PTSD by its nature is recurrent.
from what I'm hearing, and from what I've been told by my psychiatrist, mine is not always a triggered severity, which I worked 2 jobs before.
You got to decide if you want to get help for your conditions, or you don't want to get help, and you can try to figure out how to deal with your conditions by yourself, which has been wholly unsuccessful. You can decide how you want to do it.
I have a new therapist and I like her. She's been helping me a lot. And I have tried to help myself. I pulled myself out of work and I have been consistently, when I was not in jail, I was consistently going to my therapist and I was consistently going to my psychiatrist. So it's not, I haven't been unsuccessful when it comes to that.
The same people that told you not to go to NeoCap because they have cognitive behavioral therapy.
She didn't say not to go. She just said that she doesn't think that I would do well with my condition being within NeoCap.
Okay. And once again, that's why I don't have people go to Signature Health. Ms.
Do you
Cutts?
recommend usually people go to Crossroads?
No, and especially not Crossroads. Ms. Cutts?
Thank you, Your Honor. As is a situation, I know the court is aware, when the police were called, Mr. Joyner was indicating he wasn't able to leave the residence and he wanted to leave. The police came, nobody would open the door. They specifically were asking the defendant to open the door. Her voice was closer to the, after the officers on the outside of the door asking, then they heard motions and it sounded like an assault was in progress. They did kick in the door. When they entered the residence, they saw the defendant striking Mr. Joyner in the living room. At that point, 2 were separated. Mr. Joyner was found to have a bump on his head. He did have some physical harm. They had been in a relationship for an extended period of time. The relationship obviously facilitated the offense, which is obviously part of what domestic violence indicates. In this case, the defendant's daughter was in the residence as well while this was occurring. At that time, I believe she was either 6 or 7 years of age. During the time that the police were trying to take the defendant into custody and remove her from the residence, she was resistant to that, sitting down, screaming and yelling, creating quite a scene in the location. As the court indicated, they did have to call other departments for assistance in removing her from the apartment. When she was in the police cruiser, she was also kicking in the cruiser. When she got to the Lake County Jail, she did cooperate to the state's understanding with the jail staff. Defendant does have a history of juvenile adjudications as well as adult convictions. Her juvenile conviction or adjudications began in 2004 with a domestic violence misdemeanor of the 4th degree. She did have a probation violation for fighting and for cutting her ankle monitor. Her probation was continued. In 2007, she had disorderly conduct adjudication. It began as an F4 assault but was reduced to the disorderly conduct. 2008, an adjudication for disorderly conduct. 2009, she had first a single assault case and then a second case with 2 counts of assault. She had a probation violation in that case. In 2010, as a juvenile, she had an adjudication for domestic violence found in 4th degree and then a separate case with 2 counts of assault misdemeanors. There was another case that was just dismissed as assaultive nature. As an adult, she began her criminal convictions in 2011 with a misdemeanor domestic violence. She did have a probation violation in 2012. She had 2 different cases. One was assault misdemeanor. The other was attempted aggravated assault, felony 5. assault M1, and criminal trespass M4. 2016, she has disorderly conduct taunting. 2021, possession of marijuana and separate disorderly conduct. There also appears to have been another disorderly conduct that she failed to appear for. It does not appear to be a conviction. I believe was sent to collections. She has had other interactions with law enforcement that did not go through to court. There's an active protection order out of Cuyahoga County. The state's understanding the defendant's parents, Candace and Robert Rood, received a protection order that began on June 3rd of 2024 and is in place until June 2nd of 2029. As far as indicated, there were concerns in the jail with not listening, with bullying and threatening per the jail's information. Defendant did violate her bond. Her bond was revoked after she was in contact with Mr. Joyner. Very soon after she was released, she attempted to call him multiple times and then sent him text messages. He was not responding to those. The information that the state received yesterday is that as recently as Friday, the defendant was trying to contact Mr. Joyner and he said he just hung up, but she's also his family and trying to add them on social media. He would like that to all stop and he just wants them to move on. Gave additional information to the court in chambers as well. Based on all of that, the state is concerned whether the defendant will follow rules of probation. She hasn't had a felony since 2012. This is her second adult felony. Does have a history of assaults and domestic violence. If the court does give her an opportunity at community control, the state would request some sort of either neocap or residential treatment. We are concerned about her being out in the community without that additional support of an inpatient setup. She has 86 days credit. We also ask for a mental health evaluation, follow all recommendations, a psychiatric evaluation regarding medications, follow all recommendations. She engaged in anger management, individual trauma counseling, no use of drug and alcohols, that all screens come back negative. That she have one doctor, one dentist, one pharmacy, unless specialists are needed, that she sign all releases. She's prescribed any medications, that she take them only as prescribed. She engaged in full-time work, that she have no contact with Mr. Joyner, whether it be through family, through other people, through calls, through text messages, no contact, and that she be aware if she's given this opportunity, if she violates, she would be looking at 18 months in prison. And that would be the state's recommendation at this time.
All right, I've reviewed the pre-sentence report and the psychological evaluation, listened to the defendant and counsel. I've considered all the provisions of 29, 29, 11, and 13. I'm going to place you on community control for 5 years. You're going to serve 106 days in jail with credit for 86. You're to have no drugs or alcohol and you'll be screened. You're going to enter into the Mentor Municipal Court Mental Health Treatment Program and comply with all their conditions and follow all their recommendations. You're to go to only one medical doctor, one dentist, and one pharmacy for prescription medication. Take your medication as is prescribed. Sign releases for probation. No contact with Willis Joyner or any member of his family, and don't have anybody else make any contact with any of them. The appropriate time obtain and maintain full employment, pay the cost and supervision fees. Ms. Wehagen, any other terms? All right. Somebody's going to come to see you in the jail by the name of Jamie Dials from the Mentor Mental Health Program. He's going to talk to you. And I suggest you don't scream and yell at him to prevent the interview from happening, that you talk to him, because they have a very specialized program working with a whole bunch of people that are in this business that can help you, but only if you want to be helped by them. Do you understand that?
Yes.
If you don't want to be helped by them, scream at them, don't do the interview, and I'll find you violated and send you to prison if that's what you want. Okay? You can either try to help yourself, because this has been going on for more than 20 years with you. And nothing you have done has worked. Nothing you have done has helped you. It's only gotten worse. So figure out if you want something or somebody or some program to help you. Or spend the next 20 years kicking around in and out of prison. That's up to you. Anything else, Ms. Cutts?
No.
Over here in 25, CR 216, Ashley Rood, violation of community control, final hearing violation. You were ordered to have no contact with the victim, and on August 16th, there was a Cleveland Police report of contact between you and the victim. Do you understand that charge?
Yes.
August 16th, you were in Cuyahoga County without permission from probation. You understand that charge?
Yes.
August 17th, arrested by Cleveland PD for assault. You understand that charge?
Yes.
All right. Ms. Tomaszek?
Yes, thank you, Your Honor. I know we were last here on September 24th, and there was probable cause found. Since then, I have talked to Ms. Rude, and she indicated she would like to admit to the violations, and we are prepared to proceed with sentencing today. Thank you.
Is that what you want to do, Ms. Rude?
Yes.
And what's your plea to those violations?
I'll plead guilty to them.
Or I'll accept your guilty plea and find you guilty.
But
What seems to be the problem here?
I'm sorry.
What seems to be the problem here?
I apologize about some of the things that have occurred. As far as assaulting my ex-boyfriend and the other woman, I didn't think that this was going to happen like that.
Why did you have contact with him?
If I'm being transparent here, we've been in contact since I was in jail in December.
Why?
We basically have been living together.
Why?
I sometimes need help financially, and he's been my financial support for the last 4 years, on and off.
Well, it doesn't seem to work.
I'm absolutely aware of that. And
Well, when did you become aware of that?
I've been pretty aware with it for the last 2 years. I was working on becoming more independent. I got another job. At the same time, also, I have been asking for financial help, and he has been providing financial help. But I am working on becoming more independent. I got another job. I moved my daughter and I to Forbes' house because I am becoming aware and learning in therapy that some things are just not healthy for me in my life. So
You got, as a juvenile, a domestic violence, an assault, disorderly conduct, an assault, a domestic violence, an assault. As an adult, you got domestic violence, an assault, attempted aggravated assault, disorderly conducts, criminal damaging, violation of a protective order in this domestic violence. Nothing seems to work. When you're on probation, nothing seems to impact you. Last time you were here, a short time ago in May, you served an additional 40 days in jail. So that got you out the middle of June, sent you to the Menor Municipal Court Mental Health Treatment Program. Told you no contact with Joyner. And 2 months later, you're at it again. So you don't seem to want to listen.
I have told my probation officer there have been several, this isn't the first incident that has happened. There have been several incidents that have happened, which is why I did try to take necessary precautions to kind of step away from our situation. I did check my daughter and I into the Forbes house. I always was in communication when it came to my probation officer about some of the things that have been occurring.
What do you mean you listen to? You don't listen to anybody. You do exactly what you want to do, when you want to do it, how you want to do it. And you've been doing that for 18 and a half years.
Well, I'm sorry.
On a constant basis. And you're only 33. So you haven't changed a thing in your life.
I feel like I've changed a lot.
When?
I feel like my temperament has changed a lot before this. I haven't been in trouble since 2013.
What do you mean you haven't been in trouble since 2013? Didn't you hear all this stuff I read off?
As a juvenile?
No, as an adult.
I don't really get in trouble with the law.
Okay. June of 11, domestic violence. June of 12, assault. June of 12, attempted aggravated assault 2 weeks later after the first assault. November of 16, disorderly conduct. March of 17, disorderly conduct fighting. August of 20, possession of marijuana. December of 20, disorderly conduct persistent. September of 21, disorderly conduct. May of 23, criminal damaging. October of 23, violation of a protection order. In here, domestic violence. In Cleveland, whatever they charge you with in Cleveland, that there were charges pending in Muni court. What do you mean you don't get in trouble?
These are usually incidents with my ex-boyfriend.
Okay. If they're from your ex-boyfriend, why do you keep getting in trouble in disputes with your ex-boyfriend?
I'm usually defending myself.
Okay. It seems to me from your record and from my contact with you, you do not know how to conduct yourself in a manner It keeps you out of jail. You don't seem to be able to do that. No matter what the conditions of any probation, how many times have you been sent to prison?
Never.
Never. Which means you've always been on probation, right? Right? How many times have you been on probation? Including this time?
Yes.
Whenever you had all these convictions in juvenile court, were you ever on probation?
Back in juvenile days, I was on a lot of psych medication, so honestly, I don't recall.
Well, you were. In June of 11, on your domestic violence in Cuyahoga County, you were on probation. You violated probation. In June of 12, in Cuyahoga County, you were placed on probation.
I had a lot
In December of 20, in Willoughby Municipal Court, well, you weren't on probation because you never showed. So why didn't you comply with the terms of probation when I placed you on probation when you got out of jail in the middle of June of this year?
I've been in compliance with probation.
Why are you here then?
Because of what just occurred.
What just occurred was the violation of the condition of probation that you have no contact, right?
I was making it to the other things that were asked of me. I was going to mental health court on time. I was sober.
You don't pick and choose what you want, what you don't want to do. You do, but you're not permitted to do that. There were some things you didn't get violated on. What were those, Ms. Henley?
Your Honor, there were prior incidences of contact with the victim.
Since being put on probation here.
Yes, Your Honor,
Okay.
documented by Willoughby police report as well as from the defendant. There was a traffic offense occurring in Lyndhurst that I was never made aware of. Nor was I made aware that she was out of county that day. I'm sorry, Lyndhurst Community. I believe the arresting agency was kind of mixed.
So there's been at least a half dozen things. In addition to the 3 that are on the record here for this violation, at least 3 more things in 2 months.
I was on the way back to my parents' house. I wasn't in Lyndhurst. I was in Mayfield.
Mayfield's Cuyahoga County.
Right.
And you
I work at Juliet.
and then you're summoned into Lyndhurst Municipal Court for whatever violation it was.
I couldn't report. That happened on the 14th, and I couldn't really report because I got arrested on the 16th.
So what happened the rest of the 14th and the 15th and part of the 16th that you couldn't report it?
How am I supposed to report? I was going to report on Tuesday, which was
Got a telephone? Got a telephone?
That's the weekend.
Okay.
I'm not usually one to not.
You not only do you not listen, okay, to what and do what you're supposed to do. Not only do you not comply with the terms of your probation, but you don't even seem to think that it's a problem not complying with the terms of probation, because every time I ask you about it, you come up with an excuse as to why you're not doing it. In the 2 months that you were on probation, this all occurred after you got out of jail.
I was on the way back from work. I had to pick my daughter up in Cuyahoga County. My parents live in Mayfield Village. I was staying at Forbes' house.
And you got some sort of ticket, right?
I was going 75 and a 60.
Okay. What? 82 and a 60. You got a ticket. And that then triggers an obligation for you to tell your probation officer.
I couldn't report yet. I was going to report on Tuesday. That happened I couldn't report yet.
Okay. All right. So there's a perfectly reasonable explanation for each of these violations.
I was really on the way back to pick my daughter up.
So is there a perfectly reasonable explanation for each of these violations?
Yes.
There is. Okay.
Not all of
Ms.
them,
Tomaszek?
but that one.
Thank you, Your Honor.
It's unbelievable.
In speaking with Ms. Rude, she would like to ask the court for an opportunity to continue doing probation. And speaking with her, she has indicated some of her mental health issues. She is currently enrolled in the mental health court through Mentor Municipal Court. We have quite a few clients in that court, Your Honor, and I've spoken with the judge and Jamie.
I spoke with the judge too.
So from what Ms. Rude told me, she has been enjoying mental health court. So she would like an opportunity to continue probation, get another opportunity to continue going to mental health court. Your Honor, I know she has a hearing on November 3rd for a custody issue with her daughter. She indicated her daughter is her main priority. She does not want to miss that hearing. She wants to make sure she can do.
How can her daughter be her main priority when she can't live her life within the bounds of what she's supposed to do. If her daughter were her main priority, then she wouldn't have gotten arrested in Cleveland on August 16th. Okay, so it's not her main priority. She says it's her main priority, but it ain't.
I'm not a bad mom, so that's really hurtful that you feel that way. I'm sorry
Well,
that you feel that way.
Well, okay, all right, great. I'm sorry that you don't conduct yourself like a responsible parent for the benefit of your daughter. Okay, I'm sorry about that. Okay, that's got nothing to do with anything. Go ahead, Ms. Thomas.
Thank you, Your Honor. So we would just like to ask the court for one more opportunity to give Ms. Rude the chance to see how mental health court can help her, what sort of things she can get from mental health court to help with her thinking. I know she wants to get back on her feet. So we'd just like to ask the court for one more opportunity.
She's going to get another opportunity, okay? Whether that be that indicates she's not going to take advantage of it because she just doesn't. For 17 and a half years, she hasn't. That indicates to me that she really doesn't have any interest in this. Her interest is in getting off with the least amount of penalty possible. And then she can go back and have contact with Joyner. But she'll get the opportunity. Thank you.
Thank you, Your Honor.
All right, I've gone back and looked at the pre-sentence report and considered all the applicable statutes once again. And as I said earlier, you were sentenced on May 7th. You got out of jail on that sentence when I placed you on community control in mid-June. And you violated multiple times, at least a half dozen times, 3 of which were filed, 3 of which weren't. And you have no concept of why you do what you do. Because you indicated to me that there was a perfectly reasonable explanation for each thing you did. You have no insight into what you're doing, why you're doing it, and how to stop doing it. Now, I'm going to keep you on community control for the same term. You're going to serve 95 days in the jail with credit for 35. After that, you're going to go to NeoCap. You're going to complete that program and follow those recommendations. And you're going to continue in the mental health treatment program. You're going to comply with all those conditions, as well as all the other conditions that I imposed upon you for your probation on May 7th, including no contact with Willis Joyner or any other member of his family.
Can my daughter and I also have a no contact order?
Can your daughter and you also have?
Yeah, because this communication doesn't just go one way. Okay, I reached out to Joyner. He reached out to me.
Okay.
So this is ridiculous that I'm being placed with all these different regulations. Right. And I'm also not
I understand in light of your history how absolutely ridiculous this is.
I can lose custody of my daughter.
Once again, because you bear no responsibility in any of this.
You don't even know me as a person. You're going by a piece of paper.
Right.
That's
right.
I can lose custody of my daughter.
Anything else, Ms. Tomazik?
Nothing further, Your Honor. Thank you.
All right.